Each Wednesday at this time of the morning we are talking labour law to Michael Bagram of Bagram's Attorneys. We've looked so far at what the employer should be doing and what the employee should be doing, employee or worker, if you like to separate, it makes it easier to understand. Often talked about is unfair labour practice. This includes promotion, demotion, probation training, provision of benefits, unfair suspension, disciplinary action. All sound very complicated, Michael. How does one cope with all of these things?
Thank you, Leslie. We as attorneys do advise employers on a regular basis on these issues. The variation of the conditions of service is a big issue right now, and obviously what the economy is doing at the moment would mean that people do need to vary the conditions of service. We've had many people coming on to the discussion and saying that we need to, for instance, lower people's wages or salaries. And so we do that, but you've got to do it properly. Otherwise it becomes a real problem with specific forms of unfair labour practice. So let's, for instance, look at some of the topics that you raised earlier on, such as promotion. Some people, for instance, would get promoted. Others might complain and say, why did you promote Joe Soap instead of me? And you'd have to have a specific process as to how it's done, and you need to have a specific outline as to why you've done it. And you need to do it through discussion, negotiation and consultation.
That would depend on a person's expectation.
Correct.
And if somebody's being promoted over my head, for example, I would be obviously upset.
I would be upset, and then you would have to then approach your employer and say that I think it's unfair, I want to challenge you, I might raise a grievance, I might refer it to the CCMA. So promotion can have a whole host of complaints that go with it. One normally doesn't think that way. You think promotion is just a happy thing, and that person that's promoted will not complain. Well, it's not normally the person that's promoted that complains. It's the others who say that they were in line and now I want to challenge it. And we've had a lot of disputes of this nature. So we consult with the employers and we explain how the promotion process ought to be handled carefully, just in case it backfires and is a complaint. If we go on to demotion, obviously demotion is the other side of the coin, and there it is actually a punishment for that particular employee, unless of course it's done by agreement. If it's done by agreement, then it becomes a lot easier, and you would reduce that to paper, you would get both parties to sign, and there'll be no problem at all. But the demotion unfortunately does lead to disputes. It leads to individuals complaining once again to the bargaining councils or to the CCMA, and we at Bagram's Attorneys need to go and defend the employer at the CCMA or the bargaining council, and that defense becomes very difficult if you haven't had a process leading up to the demotion. The process is all important, almost as important as to the reason why you've demoted the person. How did you demote them becomes just as important, and in fact the CCMA spend a lot of time and trouble looking at those particular issues. We must move on to something like probation training. You can't say someone's on probation, so therefore they're not working out, I need to tell them to go. You need to give them the training, you need to give them the wherewithal to be able to handle the job properly, and it becomes a problem if you haven't done that properly. We look often at the provision of benefits to employees. For instance, you can't give half your employees a medical aid benefit and the others not. You can't do that, and that becomes a specific form of unfair labour practice. Everyone has to have similar benefits for similar expertise and for similar periods of service. You can't go and do it separately for someone else. You can't suspend someone without having a proper suspension discussion. We normally call them suspension hearings, and we at Bagram's Attorneys unfortunately have gone to fight many of these suspension hearings where an employee says, I was suspended, I'm not sure why. Also, you must remember that suspension is done on full pay with full benefits during that period of suspension. We also look at issues, as attorneys, we look at issues such as disciplinary actions short of dismissal. For instance, if you're going to suspend someone for a week on no pay, that must be done properly through a disciplinary hearing itself, and that is an action that you take which is short of dismissal. Once again, the process is all important, and we have a proper outline for our employers to explain to them how it must be done so that there's no comeback. It's a lot cheaper to speak to your attorney to pay for an hour's consultation than to have to go to a court case and actually lose it. We will have discussions also on protected disclosures. In other words, people who come and complain, for instance, to the receiver revenue about their employer. That is a protected disclosure under certain circumstances.
So you can see there's an awful lot that goes on before, during and after an employment takes place. Next week we'll cover further aspects of the labour law and labour practice in South Africa. Michael Bagraim can be contacted at Bagraim's Attorneys by email at michael@bagraims.co.za or by telephone. They're in the book.